Let's discuss the ethical and legal expectations for auditors. And to examine some of these legal and ethical expectations, we'll be looking at HealthSouth Inc., an instructional case examining auditors' legal liability, written by Ronald Daigle, Tim Louwers, and Jan Taylor Morris. With such a large fraud, the case study, as well as other observers during the time period, asked whether the audit firm that performed HealthSouth's audit was complicit in the fraud. HealthSouth used Ernst & Young, one of the Big Four firms, to perform their audit. From their early days of incorporation up until the fraud was detected, the shareholders of HealthSouth Corporation sued Ernst & Young as part of their class action lawsuit against HealthSouth, alleging that Ernst & Young had knowingly turned a blind eye to the very fraudulent and illegal practices by which HealthSouth falsified its financial statements. We'll look at examples of what's required of audit firms and what Ernst & Young actually did. But, as a spoiler alert, Ernst & Young ended up settling the case for $109 million. Auditors are expected to abide by certain codes of conduct. These include the rules specified by the Securities and Exchange Commission, rules specified by the Public Company Accounting Oversight Board, which sets standards for companies that audit publicly traded corporations, as well as, and perhaps most importantly for this case study, the American Institute of Certified Public Accountants. Their standards are established for AICPA members and have three primary areas of focus. First, the broad principles are the aspirational goals or behaviors by which accountants should abide. These give way to more detailed rules. The rules are enforceable ethical regulations that CPAs must follow. And the rules set forth three groupings of rules depending on what you practice and whether you practice. Finally, the AICPA establishes interpretations. These are applications of rules that deal with specific business situations. These don't have the weight of rules. Instead, they guide CPAs in ways that they believe a CPA should act in a given situation. These rules are important because courts of law have, by association, applied these rules and codes of conduct to people who practice in accounting, even if they're not auditors and even if they're not members of the AICPA. The AICPA established 3 sets of rules depending on whether you're in public practice and whether you're currently practicing. The highest set of standards apply to CPAs who operate in public practice. That is, CPAs who perform audits of publicly traded companies or audits in general. These rules require CPAs to be independent in mind and independent in appearance. It establishes rules for the fees that they charge, forbidding them to use contingent fee structures for their audits. It sets specific requirements for advertising, as well as business form name, and it establishes a confidentiality requirement. The next set of rules applies to all CPAs who are working presently. This includes tax accountants, as well as CPAs who work in ordinary business structures. These rules include integrity and objectivity, looking at things from a clear perspective, complying with the general standards, and following generally accepted accounting principles. The third grouping of rules apply to all CPAs. Specifically, it establishes a list of acts that can cause a CPA to lose their licensure. This includes failing to pay your income taxes. Some of the rules of professional conduct include the responsibilities for CPAs. They should exercise sensitive professional and moral judgments. They should honor the public trust that has been placed in them. They should act with the highest sense of integrity, doing the right thing for the right reasons. They should look at their assignments with a viewpoint of objectivity, that is, being impartial, unbiased, and independent, and free from conflicts of interest. They should apply the standard of due care, that is, they should be diligent, competent, thorough, and prompt in performing their duties. And they should also be aware of what they're doing and how they should act when they're performing their services. CPAs who work in public practice, that is, CPAs who perform financial statement audits, have to abide by the independence rule, which is specified in the AICPA Code of Conduct, section 1.200. This requires auditors to be independent in both mind and appearance. By independence in mind, we mean that an auditor will not be forced to make a decision between their own financial well-being and the well-being of the shareholders they've been hired to represent. This forbids auditors from acquiring stock in the companies that they audit, as well as holding major financial interests in that company, such as debt. Another standard for independence in mind means that auditors cannot cross that line between being an auditor and serving as client management. Auditors make recommendations to improve internal controls, but they cannot implement those controls themselves. Likewise, auditors can ask employees of the company that they're auditing for information related to their audit, but they can't ask those employees to make changes to the book as a result of their audit procedures. Another way that auditors maintain independence in mind is by refusing services that impede judgment. These services are specified in the PCAOB standards, the AICPA standards, as well as the Sarbanes-Oxley Act of 2002. Independence also means maintaining an appearance of an outsider. That is, If an outsider were to walk in on you performing your audit duties, would they think that you are an employee of the firm, or would they think that you're an employee of the company that you're auditing? If the answer is the latter, your independence can be impaired even if you don't hold financial interest in the company or cross that line between being an auditor and a manager. While these independence rules apply specifically to auditors participating in an audit engagement, it also applies to other parties with whom the responsibility of maintaining the public trust lies. This includes an individual in a position to influence the engagement, such as a specialist, a partner or manager who provides non-attestation services to an attestation client, so a tax manager making a tax advising case to a publicly traded corporation, a partner in the office where the engagement partner practices, someone who's employed by the accounting firm's benefit plan, and an entity that can be controlled by any person considered a member, that is, a wife, a child, a parent, or those with proximity to those whom the independence requirement directly applies. In a word, independence isn't just for auditors. As part of the economic recovery following the Great Depression, Congress took an interest in regulating publicly traded stocks. The 1933 Securities and Exchange Act provided guidance for the initial registration of securities. This included the requirement for new securities to undergo an audit of their financial statements. It also included limited accountability for securities fraud, especially for those who attempted to defraud potential investors in establishing publicly traded corporations. The 1934 Securities Law is the one that more deeply involves auditors. It required publicly traded companies in existence to file quarterly and annual reports of their financial performance. Annual reports were required to be audited, and quarterly reports underwent some type of an attestation engagement. The 1934 Securities Law also required disclosure of significant events on the 8K form. This includes changes in executives and changes in auditors. It also expanded the definition of fraud to include insider trading and other more broadly defined fraudulent schemes that had the intention to deceive. In a nutshell, those complicit in defrauding investors would be held accountable under the law. One of the changes under the 1934 Act was the expanded definition of fraud, which can be applied to financial statement auditors performing audits under the rule. An audit firm need not to be directly involved or have knowledge of the fraud in order to be held liable. Auditors could be found guilty of what's called gross negligence. Under these requirements, if the shareholders suffered damage, if the financial statements contained a material misstatement, and if the shareholders' loss was caused by reliance of those financial statements, the auditor could actually be held responsible under the doctrine of constructive fraud. However, if the auditors acted knowingly, that is, with legal scienter of the situation, they could be held liable for a broader definition of fraud. Sarbanes-Oxley Act of 2002 expanded these requirements established for auditors and audit firms. In performing audits, The Sarbanes-Oxley Act of 2002 required auditors to expand their testing to include the evaluation of internal controls over financial reporting and to report any deficiencies they detected in the internal control structure. It also held auditors to a higher level of accountability, imposing penalties for destroying records, for lying, and for violating their clients' trust. While this act had not yet been passed when the HealthSouth fraud had been perpetrated, the rumblings were everywhere. Despite these legal and ethical standards placed upon auditors by laws such as the Securities and Exchange Act of 1934 and the Sarbanes-Oxley Act of 2002, as well as ethical standards such as the AICPA Code of Conduct, there's also an implicit recognition that auditors can't do it all. Audit procedures, as stated in the Auditor Basis for Opinion, involve assessing the risk of material misstatements. They use their identification and quantification of risk to evaluate where the greatest areas of potential fraud exist and design testing procedures related to those risks to collect evidence related to their assertions. As a whole, they can never provide an absolute assurance. Rather, only a reasonable assurance based on the risks they assessed and the procedures they performed. This was the defense of the Ernst & Young firm when they faced Congress and when they faced the shareholders in litigation. They alleged that collusive fraud, which occurred in the HealthSouth case, is difficult to detect. Even the best system of internal controls can be manipulated by people working together to overcome the structure of controls. However, the shareholders in their lawsuit alleged that Ernst & Young was far from independent in carrying on the audit procedures. The Alabama office that performed the HealthSouth audit was reliant on the corporation for revenue. Roughly $3.5 million came from the HealthSouth client each year, their single largest client. They also had a number of their former auditors go to work for HealthSouth in high financial positions. This was another restriction that was later addressed by the Sarbanes-Oxley Act of 2002. With regard to the performance of the audit responsibilities, their duty of care, the lawsuit alleged that Ernst & Young downplayed whistleblower complaints about the alleged fraud. The audit team was aware of a weak control environment, and although they may have performed additional work as required by the standards, they may not have done enough work. Another allegation of the lawsuit was that certain account balances demonstrated wild fluctuations. Had the auditors performed basic analytical procedures, they would have noticed these fluctuations and would have investigated them further. Another fact indicating that EY breached their duty of care was the fact that the HealthSouth internal auditor was denied access to records. This should have been a red flag. Anytime you can't get the records, you shouldn't be doing the audit. So now it's up for you to decide. Read the supporting documents that are referenced on the Moodle page and respond to the discussion board post on Moodle.